Good afternoon, everyone, and thank you so much for joining us for this seminar today on Florida's new social media law. My name is David Karp. I'm an appellate lawyer at Carleton Fields, and I am chair of the Florida Bar Media and Communications Law Committee. The committee exists to provide a forum for members of the Florida Bar to share information and ideas about the law, free speech, and communications, and also to promote a better understanding about the court system and the law between the bar, the public, and the news media. We have a very timely topic today that we're quite excited about, because next week, next Thursday, the U.S. Court of Appeals for the 11th Circuit will hear arguments in the case NetChoice LLC versus Attorney General of Florida. And this is a case that is challenging on First Amendment and preemption grounds Florida's recently passed social media law. Now, Florida, as well as Texas, were some of the first states in the country to pass new laws regulating how social media platforms can manage, present, or edit posts on their platforms and also regulate users. And when the law was passed, NetChoice sued and sought a preliminary injunction, which was entered by U.S. District Court Judge Robert Hinkle in Tallahassee. The state has appealed, and next week, the three judges on the 11th Circuit panel are Judge Kevin Newsom, Judge Edward Carnes, and Judge Gerald Schoflat. And Florida will be represented by Brian Barnes. He's a partner at Cooper and Kirk and a former law clerk to Justice Alito. And NetChoice is represented by Paul Clement, the former Solicitor General of the United States. So we're really excited for our panel today. We sort of have an all-star cast of people who really know this area of the law. Our first speaker is Eric Goldman. Eric is the Associate Dean for Research and a Professor of Law at Santa Clara University School of Law in Silicon Valley, where he also co-directs the High Tech Law Institute. So this is a pretty great quote. Wired said of Goldman, "One man who has had an outsized effect on the way Section 230 is treated in public discussion is Eric Goldman. He is a prolific blogger, keeping seamlessly exhaustive tabs on the latest developments in internet law. Goldman has been writing about this area for so long that the Stratton-Oakmont ruling, which Section 230 was created to overturn, cited a paper he wrote as a student." Our next speaker is Pam Marsh. Pam is the president of the First Amendment Foundation of Florida, and she is the former United States Attorney for the Northern District of Florida. She was the first woman ever appointed to that post. When the legislature is in session and I need to find Pam, I can count on her being in the halls of the Capitol, tracking legislation and trying to keep tabs for the public and Florida's media on what bills are being passed in Tallahassee. We're really honored to have Chris Marchese, who's counsel at NetChoice, the plaintiff in this case, as our guest today. Chris analyzes legislative and regulatory issues at both the federal and state level, including proposals to amend Section 230 of the Communications Decency Act. He's also worked on Capitol Hill, and he has a law degree from the Antonin Scalia Law School at George Mason University. And our last guest is Eugene Volvic, who is well known and is a professor of law at UCLA School of Law. I've been reading his blog, the Volvic Conspiracy, for many years, as probably many of our attendees have as well. He is a First Amendment and constitutional law scholar. He's published a textbook on the First Amendment and academic legal writing, which many law students read. He graduated from UCLA with a BS in math and computer science at the age of 15, which is probably the most impressive thing on your resume, Eugene. He worked for 12 years as a computer programmer, also clerked for Justice Sandra Day O'Connor and on the US Supreme Court, and Alex Kaczynski on the US Court of Appeals for the Ninth Circuit. So while we begin our discussion, I would encourage the audience to please submit questions to the question and answer feature on Zoom. Now, we may save some of these questions for the end, but I would encourage you to post the questions during our conversation, because if there's a question relevant to the issue we're discussing, I'll just go ahead and present the question at that time rather than waiting for the end. So don't hold back. Okay, so we're going to begin by just sort of setting the stage and introducing the law, and I'm going to start with Pam. And Pam, the first question I have is, how did we get this law? Where did it come from? What were the political forces in play, and how did it get through the legislature, which is one of your stomping grounds?
Well, thank you, David. Yeah, so before we go forward to the litigation, let me take you back to where we were in early January 2021. There was a social media provider called Parler that branded itself as an alternative to Twitter, and its hashtag was Where Free Speech Thrives. Parler was hosted by Amazon Web Services, and for weeks prior to the January 6th attack on the US Capitol, Amazon had been warning Parler that it needed to do a better job of looking out for hate speech and for speech threatening violence. And some Parler users were calling for election-related violence. In fact, Parler was used by some to post and communicate during the January 6th insurrection. Then about a week after January 6th, Governor DeSantis spoke at a conference at the Texas Public Policy Foundation in Austin. He told the gathering that preventing censorship by big tech companies was, quote, probably the most important legislative issue that we're going to have to get right this year and the next year, end quote. Well, at the First Amendment Foundation, we were already in the midst of our legislative tracking. And when we read about the governor's pronouncement of this legislative priority in the Miami Herald, we definitely took notice. But lawmakers in Florida, in Tallahassee, took notice too. They began calling it selective censorship when social media companies took down conservative opinions. To us, it seemed pretty simple. We wrote a short letter to the Senate Governmental Oversight and Accountability Office on April 5th, in which we pointed out, A, the First Amendment doesn't apply to private companies. That's basic second-year constitutional law, right? The First Amendment says Congress shall make no law abridging the freedom of speech. And then, of course, that gets applied to state and local lawmakers by the 14th Amendment. And then B, we knew from the Supreme Court's many opinions on the subject that compelling speech is as much a violation of the First Amendment as silencing speech. So forcing a social media provider to host false or inflammatory violent speech was going to be a problem. And then finally, C, we knew there's Section 230 of the Communications Decency Act, which has been around for quite a while and prevents imposing liability or penalties on a social media provider for what a user posts on their site. As you know, 230 has been around, like I said, and there have been many cases already interpreting it. So right out of the gates, we were raising red flags regarding compelled speech as a violation of the First Amendment and preemption by Section 230 of any law that attempted to penalize social media companies. But as the bill, SB 7072, went forward, we saw that it got jam-packed with so many other issues that we never saw coming. There were multiple vague, convoluted definitions and verbiage thrown around in the bill, like social media platform and algorithms and deplatforming, shadow banning, and a pretty significant definition of what censorship is. There were also greater penalties placed on the removal of posts by political candidates and a definition of journalistic enterprises that was quite controversial. Have I missed anything major, David?
I don't think so. I mean, one thing that was of notice was that the law didn't apply to certain types of social media platforms, and particularly ones that owned a theme park. So tell us, what was that about?
Oh, right. Oh my gosh, I can't believe I forgot that one. It's my favorite, most favorite of all. So there was an exclusion for large Florida theme parks. And it doesn't take a genius to realize that picking and choosing among voices we like and voices we don't is plain old content discrimination. It's funny to look back now at that exclusion because I think it was really intended for Walt Disney World. And I wonder if anyone is having some second thoughts now following the 2022 session about throwing this special bone to the Florida mouse. I'll end on this because I think there'll be some really interesting discussion about it. And I didn't see this argument coming, that social media providers are like newspapers, and therefore they have editorial judgment that's protected by the First Amendment. I hadn't thought of that until I was reading the pleadings and listened to the hearing before Judge Hinkle. And I think that's a really interesting argument, especially the way we're going with newspapers more online. And I look forward to hearing the other panelists talk about that, but I'll leave it to David and be quiet now.
No, not at all. That's a great point, and I know we're going to dive into that really quickly. Just before we do, Chris, your association NetChoice represents social media and other tech companies. Were there provisions in the bill that your clients took notice of? Are there any parts of the bill that Pam didn't talk about that you want to lay out for our audience?
Sure. So first, David and Florida Bar, I just want to thank you for having us today. I think this is a great topic, like you said. And second, I want to thank Pam for giving such a good overview of the law because it saves me a lot of trouble. The only thing that I want to highlight that I think is worth elaborating on is the law's requirement that social media platforms moderate in a so-called consistent manner. The law does not explain what that looks like. And it also does not explain what companies should do when the law itself requires them to moderate in an inconsistent manner. This was something that came up throughout our case because basically the state could not explain how it will know when platforms are moderating in an inconsistent manner. So this, of course, raises vagueness concerns under the First Amendment, but it also raises due process concerns. It's pretty standard in American law that you can't be held liable for something that is open to broad interpretation and does not give fair notice of what is actually legally required. So I want to just hit on that. The second thing, too, is that the law has special rules for special groups. In particular, the law requires that platforms host almost all content that comes from political candidates and from so-called journalistic enterprises. While these phrases may sound, intuitive, like people know what a political candidate is, we think we know what a journalistic enterprise is. The facts are Florida went with a different approach. They defined both so broadly that more or less anyone in Florida who wants to be able to post whatever they want has a way of getting to that conclusion because of these carve-outs. And then lastly, the law has very onerous disclosure requirements. In particular, they require our members to disclose how they moderate in particular detail. In fact, I think the phrase the law uses is that it must be thorough and detailed. And the reason why this is particularly concerning is because while we want to give the public a sense of standards and an idea of what is expected of them on these platforms, we don't want to give a roadmap to bad actors so that they can escape detection from algorithms and human reviewers that are on the site to police the site for safety. So, one of the declarations that was filed in the lawsuit came from a child protection group that pointed out if you give bad actors a roadmap to escape detection, it's going to hurt children. And so I think, from top to bottom, the law is flawed in terms of the First Amendment, but it is also flawed in terms of its practical effects.
Yeah, and there's some pretty significant penalties in this law, right, Chris? I mean, it's if I'm not mistaken, and please correct me if I am, for certain violations of certain provisions, you can face a private cause of action, an action by the Attorney General, $100,000 in statutory damages, punitive damages, actual damages, injunctive release, in some situations, attorney's fees. And then for violations of the provisions that deal with candidates, you're talking about a $25,000 daily fine, or for candidates who are statewide candidates, a $250,000 daily fine. So these are enormous penalties that would quickly add up for many companies. Let me turn to Eugene, because Eugene, I was reading the briefs in this case and also reading your article on treating social media platforms as common carriers. And I was struck by how many ideas and arguments in these briefs really come from some of your scholarship. And so, you know, if we assume for a second that the legislature thought they were enacting a law that was constitutional, that didn't violate the First Amendment, take us through some of those arguments for how parts of this law or all of the law might be consistent with the First Amendment. Oh, you're on mute.
I'm not a fan of this particular law for some of the reasons that were mentioned. The special treatment of candidates may very well be an unconstitutional content-based restrictions. The exclusion for theme parks, you know, I'm sorry there isn't someone on the Skoll who could defend this particular law as written, but I'm not one. This having been said, I think it's fair to say that I'm more open than the other people on this call to the possibility that some such laws might be constitutional. Let me just quickly lay out what I think of as a spectrum of platforms. On one side are newspapers who decide what to publish, sometimes from their own people, but sometimes from letters to the editor or columnists. They have a First Amendment right, no doubt, to decide what to publish, what to include, and what not to include. And what's more, we rely on them to deal with problems of information overload. If they didn't publish, if they didn't do this selection, they would be useless to us, right? If a newspaper didn't sort of choose just the columnists that it thought were good columnists who had smart and accurate things to say, that would be a pretty poor newspaper. And magazines are just like that, although magazines tend to be more likely to be expressly opinionated. Let's look at the other extreme end of the spectrum, a phone company. Let's say somebody says, you know, this phone company is using the phone services, or excuse me, is providing a phone line to the KKK or to the Communist Party. And it's a publicly accessible line that that this bad organization is using for, maybe there's an outgoing message it's propaganda that people can call, or people can call and talk to a volunteer who will explain this position, or maybe they do get out the vote drives. So they use the phone system as a means of mass communications, to be sure, one phone call at a time. And so they say, well, we demand that the phone company take this down. The phone company's response is, we can't, we're not allowed to. We're a common carrier. We are required to host everybody. I mean, so long as they pay the money. It's not our job to be the censors deciding what is evil, what is hate speech, what is the advocacy of violence. If some of it is actually illegal, well, then presumably prosecutors can prosecute and will help by turning over our records. If it's not illegal, well, then neither the government nor we can suppress it. Same thing for UPS and FedEx. Imagine UPS and FedEx says, we refuse to deliver books sent by this socialist bookstore, because, you know, that's a socialist bookstore and we're anti-socialist. We're pro-free market. Well, the answer is they can't. They're common carriers. And then there's some other things which aren't exactly common carriers, but kind of like them. So, for example, in some states, only a few, my own California, not Florida, but the legal system, usually through the state Supreme Court, has chosen to say that large shopping malls have to allow people to come onto their property in order to leaflet or speak or whatever, and have to do that in a content neutral way. So that means they even have to allow evil people. I mean, people who are way outside of the mainstream to do that. Well, the Supreme Court has said that is permissible. It's not required by the Constitution, but if a state wants to enact a statute like that, or a common law rule, or a state constitutional rule, there's no First Amendment violation. Requirements of hosting, at least in certain situations, aren't necessarily unconstitutional speech compulsion requirements. Let me give you two other examples. There's a federal statute that requires cable companies to essentially host certain over-the-air broadcasters, even if they choose not to. It's very complicated. I oversimplify here. The court upheld, by the way, to be sure, 5-4. The earlier case, the shopping mall case, was 9-0. This was 5-4, but it still upheld this requirement, saying, essentially, a requirement of this kind of hosting is constitutionally permissible. And the last example I want to give from the cases is Rumsfeld v. Fair, where Congress said universities have to host, if they have recruiting programs where employers can come and recruit, they have to host on equal terms military recruiters, even if they'd rather not, because they recruit military recruiters at the time discriminated based on sexual orientation. Supreme Court unanimously upheld that. Now, the university said, this is awful. We don't like this speech. People might think it's our own speech or that we endorse this speech. And the court said, no, this kind of requirement is permissible. And if people think you're endorsing it, explain to them, no, explain to them you're just following the law. So those kinds of requirements are constitutional. And I think certain kinds of laws, not the Florida law necessarily, but certain kinds of laws that say social media platforms can't ban real Donald Trump or other people based on viewpoint, or they can't say what Twitter is saying. There's a situation where I think it was Rachel Levine, who is a admiral in the Public Health Corps, is a male to female transgender person, and Dr. Levine was given the award of being Woman of the Year by Time. And Babylon Bee, which is a conservative Christian satire site, said Dr. Levine is given the award of Man of the Year, sort of suggesting an opposite, not suggesting taking an opposite point of view on this transgender rights question of who counts as a man and as a woman. Well, Twitter banned that because it said this violates our hate speech policy. It is definitely Twitter's private property, and it's a perfectly plausible position to say that Twitter and Facebook and YouTube, which is say Google running YouTube, should be perfectly free to do that. I sympathize a lot with that. But it's also plausible to say that their role in society has gotten a lot closer to something like a phone company or UPS and FedEx, that as to at least situations where somebody is sending things to their own subscribers, where it's not like it's going to be spam that ends up in unwilling recipients' mailboxes, but comes to their own subscribers, or of course, people who subscribe to Twitter feeds and follow this, that's something that has to be treated by the platforms in a viewpoint neutral way. So I'm not necessarily an enthusiast of this kind of situation. As a general matter, I think there are very few problems that are so bad that regulation can't make them worse. So it may very well be that further regulation is just not a good idea. But I'm skeptical about the arguments that this kind of neutral hosting requirement is a First Amendment violation. Look, if universities can be required to host military recruiters whose positions or whose practices they sharply disagree with, think are deeply immoral, and then it seems to me that that platforms could be required to host on an equal footing speakers that they disagree with as well. I would distinguish situations where the platforms are recommending things. I think when the platform is saying, here are pages you might like, at that point, that is a lot more the platform's own speech. But when it's just hosting things, that sounds to me like more the situation in the cases that I described and in the phone company and UPS and FedEx cases. To be sure, not identical. That's why they're analogies. But I do think it's analogous enough to that set of things that's at least a potentially viable area for regulation, whether or not on balance we think regulation is a good idea.
So let's unpack that concept of hosting a little bit and sort of explore, how it fits, and how it doesn't fit. Eric, do you want to take that question?
I do, and thank you to the organizers of this event and to the Florida Bar for spurring this conversation. I think that the Florida law is one of the most important internet law developments of the last decade, and in fact, it might be I think the vanguard about really the identity of the internet going forward. Where the battles we're having over this law are predictive of the kind of battles that we're going to have over the role of government control over media for the indefinite future. So it's a great topic, and I'm glad that we're discussing it. And I'm confused by the term hosting. And so I'm going to slow us down on that particular term, in part because it does show up so prominently in the state's briefs that they've been persuaded by Professor Volokh that that something about this law protects hosting and that's a defensible ground, just like Professor Volokh just conceded that the recommendation stuff is probably not constitutional. I think the state's implicitly or explicitly backing off of defending those parts of the law. So what is left? What does hosting even mean in this context? And so I'm hoping that we can get a little bit of clarity about that. Certainly, we don't talk about the telephone company hosting content. That doesn't make any sense. We don't talk about UPS hosting the content of packages it delivers. That doesn't make any sense. But there's some notion here that Professor Volokh's advancing, that the state is endorsing, that there's some bounded set of functions that the internet services are providing that is qualitatively different than all the other things that they do that would be a zone of potential regulation. And I think about, when I think about hosting, I was trying to establish my own spectrum of different ways that services might engage in, quote, the hosting function. I think about something like Google Drive or Dropbox or Box, where there's servers that you can upload content to and get a URL. And that's all they do. They will do no further promotion of that URL. Anyone who sees that file is going to see it only because whoever uploaded it has gone out and evangelized the URL. And so we could be talking about something like that. Maybe AWS and the Parler example that Pam started with might be analogous to that. But let's use that as a model of one definition of hosting. Then there's something like a Google Groups, which I know is old school technology, but Google Groups is going to be something where there's going to be an email list that's built by the group operator, and those people can all talk to each other. Nobody else can get into that group without the group organizer's permission, but there's the conversation that's taking place that's been created and defined only by the group operator. Maybe that's what is being meant by hosting. But social media, by definition, has a whole thing of social in it. And that's the part that I'm confused about, because there's no function in a Facebook or a Twitter that's designed to be like a Google Drive, where all you do is just get a URL. And they're not really like even a Google Group. So there might be examples where there's some private conversations that are taking place that are very small parts of the overall services offered. But the whole idea is that there's a platform of interaction that's enabled by the technology. And that includes not only whatever might be defined as hosting, but the ability to send notifications to users, to have users then gather and organize that content into their own feed. And all of that is promotion. All of that is now taking that URL and doing something more that allows people to find it. So I don't really understand this notion of hosting as applied to social media. It's almost like the law is trying to say Facebook has to turn into Google Drive, or it's saying if Facebook offers Google Drive functionality, then that can be regulated, but everything else about Facebook can't be regulated. But I don't understand the crossing of the streams in any other way. I find that confusing. One more thing I'll mention is that for me, whatever hosting means, even if it's in the Google Drive context, to me, that's still publishing content if it's being made available to any third parties. It's taking content that's available to one person and making it available to one or more other people. Now, you can use Google Drive to store your own files, like a backup service where only you can get access to it. That's not publishing, though that might still be hosting. But any other function that disseminates that to third parties is what I call publication. And the moment that we call it publication, that's going to be governed under the First Amendment as if it was all the other analogies that get the highest protection under the First Amendment.
You know, Eric, I've been wondering about that because Section 230, which, you know, just may be a legal fiction, but it has this language that says platforms are not publishers or speakers of third-party content. And maybe that doesn't matter, but I'm just wondering if you think that kind of Section 230 and its definition of a platform as not a speaker kind of runs head in to the argument that the platforms are speakers and are involved in expressive content.
So to me, this interplay between the First Amendment constitutional analysis and a statute that's been enacted by Congress can get really tricky, because the terms can mean totally different things for constitutional law purposes and for statutory purposes. They don't have to mean the same thing. In fact, often they don't. And so to try to migrate anything that we've learned from Section 230 back into the con law analysis, to me, strikes me as the wrong direction. But what Section 230 says, it never uses the term platform, and it simply says these things called providers or users of interactive computer services, a term we would never use in 2022 for any other reason but the statute. But these things called providers or users of interactive computer services shall not be treated as the publisher or speaker of third-party content. And so it's saying they could, in fact, be treated as a publisher or speaker of third-party content for constitutional purposes, but as a statute, we're going to override the legal consequences of that status in ways that we think are consistent with the First Amendment. This is a speech enhancing statute. It uses the First Amendment as a floor, and then Congress said, we want to do more to promote free speech online. And Section 230 is the way to do that, by saying, whether or not you're a publisher under constitutional doctrines, we're going to give you this special legal protection under our statutory power. So it's entirely consistent to say Section 230 says that they're not publishers, but the Constitution treats them as publishers. That's like apples and oranges for purposes of constitutional analysis.
Well, it is like apples and oranges, because apples and oranges are really very similar, right? People say you can't compare apples and oranges. We do it all the time. Whenever we go to the store to decide whether to buy an apple or an orange, or whether to put an apple or an orange in the smoothie. What's going on in this wide range of cases that I described is that you've got somebody who's a property owner, often a property owner who's deeply involved in communications. Could be a cable system, could be a university. That's all universities do, is communicate. Well, they also throw parties or allow students to throw parties for each other and hook up with each other and like. But setting that aside, their job is communication. Yet they can be required to host, for example, the military recruiters in their rooms, which they otherwise use for communication. Hosting, by the way, is not my term. You look at, there's a Justice Breyer opinion, dissenting opinion, but the majority actually would have agreed with this even more in a case called USA DVA OSI, where he describes what happened in Rumsfeld v. Fair is exactly a matter of hosting. So they likewise Pruneyard, where the theory of the California courts was, look, this is the new town square, this being the shopping mall, the large shopping mall. And it has to quote Justice Breyer, host people who come in, and not just come in for one-to-one conversations, like talking to their friends. The shopping mall wasn't trying to eject them, but who want to hand out leaflets and have conversations with people and maybe put up signs and the like, or carry signs. There, the court said that is constitutionally permissible. And if you were to say, well, there's in fact, people did say this compels speech on the part of the property owner. The answer is no. It compels the property owner to allow speakers onto its property. In a sense, that's also what happened in Turner Broadcasting. It's in the business of distributing material. Well, one of the things it had to do is distribute some material it didn't want to distribute. So that's why I think that you can't just sort of turn around and say, well, no, this is publication, therefore per se there's a First Amendment violation, when the rule is essentially, look, there is a new public square in American life. That's actually something the court said with regard to social media a few years ago. There's a new public square. It is Twitter, it's Facebook, it's social media platforms. And we're going to require the owners of this public square, not owners of physical property, but in a sense you might call them owners of virtual property, to allow people on their platforms to speak to their subscribers and to those people who seek out their pages. So that's why I think just recasting it as their publishers, I think doesn't do justice to the different role that they have from newspapers or magazines, or for that matter, the different role that their hosting functions has from the recommendation function, where I agree. I don't concede that they're publishers there. I enthusiastically agree that they're publishers there and have for a long time. But when it's a matter of saying, look, we want to kick you off of this platform because you have bad ideas, that's very similar to a shopping center saying, we want to kick you out of our a shopping center because you have bad ideas, or university saying, we want to kick you out of our recruiting rooms because we think not necessarily you have bad ideas, but you discriminate based on sexual orientation in a way that we disapprove of. Or a phone company saying, we want to kick you off of our property, our wires, because you are spreading bad ideas. I don't think that those decisions to kick people off are protected by the First Amendment freedom from compelled speech.
Well, Chris or Pam, if you want to jump in and respond to some of those ideas, please do.
Sure. So there's a lot to unpack there. I just want to start by kind of defining the First Amendment right that is at issue in our court case. As the judge held in Florida and another district court judge held in Texas with a law that is kind of similar but different in significant ways, the First Amendment protects the right of businesses to moderate content. And the right to moderate content includes the right to kick people off your platform, to remove certain content, and to also prioritize that content or to downvote that content as you see fit. So that's the right we're talking about. And obviously it is different from, the rights that newspapers enjoy, but there is a very big similarity between traditional media and social media. And the similarity is simply that they are in the business of disseminating speech, right? So in the case of newspapers, yes, it is true that editors are in fact handpicking the selections. They are actively working to edit those pieces, and they are making specialized decisions. But social media platforms do the same thing on a different scale. So for example, when you sign up for Facebook or YouTube, et cetera, you agree to the terms of service. And in there is an agreement to abide by the community standards, which are how the platforms describe content moderation, right? Community standards. And I think that term is really important here, because what the platforms are trying to do is to build a community. The product that they offer the public is a forum for a certain community, right? So it is true that the platforms are generally open to the public, but it has never been the case that the platforms host everybody or host all of their speech. From the very beginning, social media has been a personalized experience. In fact, the entire product of social media is that there's going to be this company that solicits all of this information from the internet, this user-generated content, and then it's going to organize that content, and then it is going to disseminate it to the users in that community. And right off the bat, we know that communities don't want to see all types of speech or all types of constitutionally protected speech. I think everybody who's viewing this Zoom today probably understands that the First Amendment protects a lot of really awful but lawful speech. And while I agree with Eugene that we want to have a society that promotes free speech, that values free speech, I just don't think that we can get there by allowing the government to violate the First Amendment. And let's be clear that the entire reason why states like Florida and Texas are relying on the common carrier theory is because the First Amendment prohibits them from doing what they want to do under ordinary circumstances. So to get around that barrier, they want to claim that social media platforms are common carriers. And under the case law, it is true that common carriers typically have reduced First Amendment protection, but they still have First Amendment protection. And I think the most important case there is, PG&E from the 1980s, where the Supreme Court held, even if you are sort of like a common carrier or a public utility, the government cannot compel you to alter your message to the public. And I think that's really significant, because what Eugene is talking about is trying to separate out the functions of the platforms. If we stick with the example of Facebook, if I'm understanding it correctly, Eugene would have it so that Facebook hosts the majority of at least constitutionally protected speech, but how Facebook curates and promotes that content would be protected by the First Amendment. And while I understand the theory behind that, it's just completely impractical in the real world, because nobody goes to Facebook to see all content. Everybody goes to Facebook to see relevant, personalized content. And Facebook cannot deliver on that service if the government is intervening to tell Facebook that it has to host all content, including content that Facebook's users and advertisers just don't want to see or be associated with. And then lastly, I think Pruneyard is definitely a case that supports the state of Florida, but I also am not sure that it's necessarily still good law. To be sure, it has not been overruled, but I think it has been chipped away at, and I think its reasoning has been completely eroded by subsequent case law. To give you just an example, the Roberts Court has been one of the most protective courts of the First Amendment. And I just find it very hard to believe that the same court that held that California could not create a right of access for labor organizers to enter private property during specified hours on specified days, that same court is going to uphold forcing private businesses to host speech that they don't want. To be sure, the Fair Rumsfeld case would suggest that there are opportunities for the government to force private entities to host other speech. But what's really important about that case is that, first of all, it was decided under Congress's power to raise an army or a navy. And I think generally speaking, it is important to recognize that the Supreme Court allows the government more flexibility when it comes to national security concerns, right? The case was decided a few years after the War on Terror launched. And, it did, even though the court said it didn't come down to the fact that these schools receive federal funds, I think that was probably an important element of the decision, right? And here, by contrast, none of our businesses are receiving any type of handout from the government. And quite frankly, what Florida is asking for is astronomically different in magnitude and kind from what was at issue in FAIR. FAIR involved, military recruiters having equal access to classrooms on campus, as well as, inclusion in emails from the campus alerting students to when there's going to be recruiting events. And basically it required private space for private conversations in classrooms, which is clearly different from forcing social media businesses to host other people's speech and then to prominently display that speech on their public websites. So I just don't think that while social media businesses are not newspapers, they still have First Amendment rights, and they're far more like newspapers than they are, a common carrier like a railroad.
So Eugene, we have two questions. I'm going to give you a chance to respond.
Sure.
We have two questions about the Rumsfeld case, both of which Chris touched on. The first question is, Rumsfeld involved the Solomon Amendment and federal funds, and doesn't that make a difference? Which is not a factor that the Florida law has. And then the second question is raising this issue about national defense and was the constitutional importance of national defense sort of outcome determinative in that case. So let me pose those to you and also give you a chance to respond to Chris. I mean, the other thing about Rumsfeld that I always found odd myself was I thought the linchpin of the Rumsfeld case was the court saying that no one really associates recruiting with the views of a university. That if an employer or the military goes to the University of Florida, no one thinks, oh, the University of Florida endorses that employer. And so therefore it didn't impact the university's free speech rights. So maybe that's the case for social media. Maybe it's not, but let me give you a chance to bat those around.
Sure. So I do think Rumsfeld is an important case because virtually every criticism, not everyone, but certainly, let's say, most of the criticisms of this law that Chris raised are equally applicable, or in fact, were made of the Solomon Amendment in Rumsfeld. Social media platforms are places for speech and engage in speech. You bet. So are universities. They want to create a community. You bet. So do universities. Some of their users and advertisers might be upset by certain speech being hosted there. Well, many of the students and donors and professors were upset by military recruiting. So it's actually pretty close. Now, one possible distinction the court could have drawn is could have said, well, the Solomon Amendment just is conditioned on funding. So we're not going to decide the question of whether universities could be required required to host the recruiters, because we're just going to say it's okay as a condition of funding. But that is expressly what the court refused to do. It expressly said because the First Amendment would not prevent Congress from directly imposing the Solomon Amendment's access requirement, the statute does not place an unconstitutional condition on the receipt of federal funds. So it just says First Amendment would not prevent Congress from directly imposing the Solomon Amendment's access requirement. It says so unanimously. Could have decided some other way, but it didn't. So the funding condition, well, an interesting issue, was just not part of the court's decision. As to the military, look, it's true that the court may defer to the military in various ways, running the military and such. It's pretty clear that this kind of recruiting system, which was basically primarily a law school for the JAG Corps, was not sort of a matter of whether the military is allowed to use weapons in the battlefield or whatever else. And it's very hard to see how the logic of the opinion would have been any different if instead of military recruiting was the Justice Department recruiting. And so I don't think the court will say, well, Florida trying to protect the rights of its citizens to have access to this new town square is just such a less important interest than the military's trying to maximize its recruiting opportunities for the JAG Corps, that we're going to rule differently. And that I just don't see that kind of distinction being drawn, and I don't think that the opinion supports that. So that's why I think Rumsfeld is a pretty important decision here. I'm sorry, David, you had one other thing that you yourself added about Rumsfeld, and it got swamped in my mind by the other two things from the question. So could you repeat that now, and I'll answer it.
Well, just Rumsfeld's conclusion that hosting the recruiters did not infringe on the university's expressive, rights. Because no one associates hosting an employer event with adopting their views.
Right. And by the way,
but is that the case for social media?
So first of all, I think you might ask, well, I take it the Florida Republican Party has a Facebook page. Does Facebook endorse the Florida Republican Party as well as the Florida Democratic Party? No, I don't think so. No, you could say it implicitly endorses it as something that it's willing to have on its property, but you could have said the same thing about the universities. Here is what the court said about the recruiting there. Nothing about recruiting suggests that law schools agree with any speech by recruiters. Same with the social media platforms. Even the platforms don't say we agree with all the speech we host, especially when we host contradictory speech. Nothing in the Solomon Amendment restricts what the law schools may say about the military's policies. That too, I think, is really important and applicable here, which is if Facebook is worried that maybe something might be attributed to it, nothing in the law, or at least nothing in a properly crafted law, affects what it may say about the pages. We have held that high school students can appreciate the difference between speech a school sponsors and speech the school permits because legally required to do so, pursuant to an equal access policy. Surely students have not lost that ability by the time they get to law school. You can equally say, and I think it would be correct to say, that surely people haven't lost that ability by the time they get to the social media platform, and that they will be able to distinguish speech that Facebook or Twitter sponsors or even endorses and speech that it permits because legally required to do so pursuant to an equal access policy. That's not my words. That's the unanimous court's words.
Let me pivot to another part of the law, which is the part of the law that requires certain disclosures and the social media platforms to provide information to the users about their standards, their algorithms, their decisions to edit or remove posts. Eric, you've written a law review piece about this recently, so let me give this one to you. But part of the state's argument is look, what's the violation with disclosure? We have disclosure laws, even in political campaigns. And we require candidates to say certain things, even on their political ads. So why is this any different? So if you want to take that issue.
Yeah, thank you. And it's partially responsive to one of the questions in the Q&A about, is there any parts of the law that can be saved? And I think a lot of the law, the state has implicitly or explicitly conceded they can't save. But they are fighting on the disclosure piece. And there's a parallel litigation taking place over Texas's sister or peer law. And there's a big battle taking place over transparency requirements in that law as well. This is an active area of litigation, and it's really, I think, a centerpiece of the future potential vectors of regulation for government. So I use the term in my paper, mandatory editorial disclosures or mandatory editorial transparency. And what I mean by that is trying to get the publishers of content to disclose more information about what they published and why they published it. That can be statistics, that can be policies, that can be individualized adjudications. And then there can also be basically the backup required in a litigation, what I'll call the discovery material, to say, let me see everything you saw so that I can make a judgment about whether or not you followed what you said you were doing, or you made the accurate disclosures. All of those issues are at play in the Texas law. Only a subset of them are in play in the Florida law. I've been looking for analogies to these kinds of mandatory editorial transparency laws in history, and there actually really aren't that many. There have been some similar disclosure laws for broadcasters, but we know that broadcasters are not like internet publishers. And we know that from the 1997 Reno versus ACLU case that said it super explicitly. There was no ambiguity about that. So other than the places where broadcasters have been required to make these kinds of editorial transparency disclosures, we really don't have many analogies. We've never really seen legislatures say, I want to make book publishers tell us all the reasons why they will accept or reject a manuscript. And I want them to explain to each a potential author why their manuscript was accepted or rejected. And I want to see statistics published about what manuscripts they considered, and which ones, what percentage they accepted, and what are the reasons for why they didn't accept them. We just don't see those kinds of laws at all. And so we're in a little bit of a terra nova here. This is, I think, a legislative frontier. And from my perspective, these laws have two main problems. The first problem is that asking the question, saying, what are you doing and why are you doing it, to an editorial function is its own form of a speech regulation. People knowing that they have to be answerable to that will change how they behave because of the fact that they're under scrutiny. And that's by design. That's actually a standard feature of most mandatory disclosure laws, is you want to change behavior. But when we're changing behavior of editorial functions, that becomes a First Amendment problem. That's not like changing the behavior on the amount of sugar that's added to soda, which might be a standard consumer protection concern, but doesn't raise the kind of free speech concerns that are issued here. And there's a separate concern about the compelled disclosures. Professor Volokh is more of an expert on compelled disclosures than I am. He wrote, I think, one of the most comprehensive treatments of the subject recently. And in my paper, I basically gave up and said, I don't understand that doctrine and how it would apply here. I think the better argument is to focus on the speech restriction functions. Asking the questions and saying, what are you doing and why are you doing, changes behavior. And the last piece I'll mention is that I encourage anyone who thinks that editorial transparency is the solution to think about, what does that look like in discovery? What questions will the government regulators ask? And to what extent do those discovery requests and disclosures create their own set of problems? There's both a cost issue with the disclosure obligations that would be required to say, tell us if you've deployed your policy on vaccines consistently. in order to answer that, you basically have to see all of the possible vaccine-related content, disclose it to the government, and then the government goes through and does its own independent evaluation to say, I think you mischaracterized this, or you miscounted that. That sounds a lot like the kinds of things that we really don't tolerate, where the government is basically telling internet services, or I'm sorry, publishers, what they can and cannot publish, and whether or not they're doing a good job of making their editorial decisions. And second guessing them each step of the way. And that discovery consequence is its own form of censorship. It's a way of changing behavior, knowing that the decision maker is going to say, if I have to go and justify this in discovery, I'm going to change my decision up front so I don't have to go and justify it later. And so it's not only the upfront asking the question, it's also the discovery implications that never get discussed in these bills. What does it actually look like to enforce these bills? That I think create the problems with censorship here. So, and then last piece, I said it, I just want to make sure everyone didn't miss it, that trying to analogize general consumer protection disclosures to the disclosures about editorial functions when speech issues are at play is, again, an analogy that doesn't work because of the fact that the changes that are made with respect to the editorial decisions raise First Amendment concerns that changing how people manufacture cans of corn doesn't.
David, can I raise one other complexity here before we tie it up?
Yeah.
I just want to remind everyone, this is a state law. And Chris mentioned there's another Texas law that's kind of similar, but sort of different. Do we really want all 50 states regulating in different ways these international companies? How does Twitter or how does Facebook do business in Florida? If it has to do business in Florida different than it does it in Texas, than it does it in Arizona, than it does it in Washington State or Vermont. I mean, this has to be a federal issue. I mean, either Congress at the federal level decides to amend Section 230 in some way, but this, I don't know, habit trail of different state laws is just going to be chaotic.
So if I could just speak briefly to that, I'm not enthusiastic about having it be done necessarily at the state level or on the federal level. As a practical matter, I do think this raises very serious issues, and there are real costs in general to our federal system of government, where in fact many companies do have to comply with 50 different state laws. That's potentially quite burdensome. Let me just stress, this is pretty normal. Just to give an example. Let's look at publishers like the New York Times or whatever else. If they operate in all 50 states, then they could potentially be subject to different libel laws, different disclosure of private facts laws, advertisers liable for different, and merchandisers to different right of publicity laws. Actually, the choice of law rule there is the place of the domicile of the person whose rights are involved. So really, if you're writing about somebody from Virginia, you might sort of have to look up Virginia law to be sure there is a lot of similarity, but there are a lot of differences, right? There are different states that recognize different privileges in libel cases. Some states don't recognize the disclosure of private facts stored at all. The right of publicity, which again is a major issue for advertisers and for people who do merchandising, bobbleheads, T-shirts, and the like, is sharply different in different states. So this is a reality that businesses have to deal with, and especially large businesses, that's why they have lawyers, right? And you think Facebook, Google, YouTube, I'm sorry, YouTube is Google, but Facebook, Google, Twitter, they have lawyers. So I think there are real costs to the state-by-state approach. It's something that we've ended up dealing with in many ways. One of the things we have to ask is, what are the advantages? One of the advantages is that it provides for certain kinds of experiments. So it's possible for states to experiment with things and try to figure out the best approach that then maybe then eventually the federal government could provide. So I totally agree with Pam that there is real burden here. I don't think we have time to talk about the Section 230C2 preemption question, which raises its own issues, but there's real burden here. But again, it's a burden that is quite familiar to large American businesses, including large American businesses that operate in the communication space.
Well, let me do this because we are at our hour, and I feel like we could probably talk about some of these topics maybe for another 2 hours. So maybe we have a follow-up seminar on some of these issues, or just leave it for another day. But let me finish just with a quick sort of lightning round for all our panelists. I'm going to pose a couple questions and just try to give me a yes or no answer. I'm going to ask 4 questions. The first is the 11th Circuit going to keep this preliminary injunction in place? So are they going to affirm or reverse? Second question is, are they going to take it en banc? Third question is Congress going to change Section 230 before the next presidential election? And the last question is Twitter going to reinstate former President Trump before the next presidential election? So that's a mouthful. But let me start with Pam and just give a 1 or 2 word answer for each. 11th Circuit.
Affirm.
Okay. En banc?
Yes.
Oh, really? Interesting. Okay. And any change to Section 230 on the horizon?
No. Congress.
Okay.
I don't see Congress being that functional. Sorry.
Okay. Eugene?
I hope.
I have no predictions about almost everything you ask, because my predictions of the past have been appalling. So, but I will flag one thing. Imagine President Trump, who I do not support, runs again in 2024, which I hope he will not. But imagine that he does, and imagine Twitter says, "Nope, your ban stands." What you have is a situation where one of the most important platforms for people to communicate, engage in democratic discourse about democratic self-government, allows the one candidate on one side to participate and does not allow the other candidate. It's the exercise of its private property rights. One could certainly defend that. I appreciate the value of that. But is it healthy for democracy? For all that I think President Trump is unhealthy for democracy, is it healthy for democracy to have these questions about who can speak to 80 million willing listeners on this platform be made by Jack Dorsey, or be made by whoever happens to be on the board, or be made by the most influential employees of Twitter? I'm inclined to say not, but who knows?
Eric?
So I'm not sure what the 11th Circuit is going to do. I know what they should do, but I'm not a judge on that panel. In terms of Section 230, it's been clear, you already said at the very beginning, that the Republican Party, including DeSantis, have made it their primary messaging, and perhaps their only real substantive platform, to target online speech. And so if the Republicans take parts of Congress back in 2022, I would expect that Section 230 will be a major target of theirs. And we are in a battle for the soul of the internet when that's the case, because whatever they're proposing isn't actually in the best interests of the American people, or I believe even their constituents. This is all about messaging, as is the Florida bill. It was all about playing to the crowd. But the dog caught the car and now has to figure out what it's going to do with it. And we can challenge it in court when it's a state law. But if Congress were to modify or repeal Section 230 because the Republicans decide that's their major platform, that could reshape the internet in ways that none of us would favor. As for whether or not Donald Trump will ever be allowed back on a platform, who cares? He has his own platform, Truth Social. And if he wants to bloviate there to his heart's content, he should feel free to do so, but I probably won't be reading that.
All right, and then I'll end with Chris. And since your company is a plaintiff in the case, if you want to pass, I'll understand on the first 2 questions.
No, I will gladly answer. I think we are going to win at the 11th Circuit. I do not believe there will be an en banc hearing. As for Section 230 reform, I think that it is likely at some point in the future, but I think it will require unified government across the board. I do not think that Republicans and Democrats agree. Democrats want more content removed. Republicans want more content kept up. Given that very vast divide, I just don't see Section 230 reform happening during a Biden presidency, unless the Democrats, increase their majority.
Okay, and what about Twitter letting Trump back on?
Oh, well, I guess we'll see what Elon Musk and how his tender offer goes. I think it's a hostile takeover or something. I barely caught the news, but I would echo what Eric said. Truth Social is Trump's platform. It has content moderation rules. They're a little bit looser than, Facebook, YouTube, et cetera, but even Truth Social moderates content, which goes to show, users like to have a curated experience.
Excellent. Well, thank you all so much. We enormously appreciate it here at the Florida Bar Media Law Committee. This is a really timely topic. Let me give probably the most important piece of information, which is the CLE course number. For those of you who need CLE credit in Florida, the number is 5875. That is 5875. And for those of you attending the Florida Bar Convention in Orlando, it's going to be in person this year, but on June 24th, the committee is hosting its annual First Amendment seminar where we review the U.S. Supreme Court cases on the First Amendment, both free expression and free exercise. It's always a great event. This year we have Judge Jordan from the 11th Circuit, Judge Cook from the Southern District, Justice Coriel from the Florida Supreme Court, and many other great speakers. So we're glad to be back in person, hopefully for the first time. So come to that event. And again, the CLE number is 5875. Thanks everyone so much for attending. Appreciate it.
Thank you, David. Thank you, audience.
Thank you, David.
Much
Thank you,
appreciated
everyone.
invitation.